Welcome back to Jersey Matters. I'm Larry Menti. Sexual harassment charges and the Me Too movement is changing America. But what does it all mean? In a moment, we'll talk about that. But we begin our coverage of the topic with Ellen Kolodziej, who has the latest sexual harassment charges.
Thank you, Larry. After the explosive allegations against Harvey Weinstein, the floodgates opened for so many more women to come forward. And it's not just in Hollywood. It's in television news, politics, and in ordinary office buildings around the country. And it certainly looks like there will be more allegations. You could not turn on the TV in the past few weeks without hearing about disgraced media mogul Harvey Weinstein, who's accused of sexually harassing dozens of actresses.
With accusations piling up, even Weinstein's own brother describes him as, quote, sick and depraved.
You're talking about a guy who wielded so much power in Hollywood, and there were people who were clearly afraid. Even the people who spoke to him about it didn't go public.
Then the dominoes started falling, and one after another, more famous people were facing damning accusations.
Actor Kevin Spacey has sexually assaulted my son.
John Conyers gave up his role as senior Democrat on the House Judiciary Committee, and Senator Al Franken is speaking out, saying he is embarrassed and ashamed about accusations against him.
I will be resigning as a member of the United States Senate.
And the list just goes on from there. Actors Richard Dreyfuss, Dustin Hoffman, Jeffrey Tambor, Jeremy Piven, and Steven Seagal, all accused of harassment. Comedian Louis C.K., singer Nick Carter, and celebrity chef John Besh. Journalist Mark Halperin, Disney animation chief John Lasseter, and NPR news chief Michael Orikis. But wait, there's more. Amazon executive Roy Price, U.S. Senate candidate Roy Moore, and even former President George H.W. Bush stands accused of inappropriate behavior. But perhaps the biggest bombshell so far, NBC fired longtime anchor Matt Lauer for yet another case of inappropriate behavior. More stories keep coming out, and Hollywood started it all.
And I think it's because women in Hollywood and men who care about this want this not to be a moment, but a transformational time in history.
Now, some of the victims in these cases have already settled, and some people have walked away with millions of dollars. As for the harassers, some of them have lost big jobs, and some could even face criminal charges. Reporting for Jersey Matters, I'm Ellen Kolodziej.
All right, thank you, Ellen. Now let's find out how all of those cases that are making national headlines are reverberating in the workforce. Lori Armstrong Halber is a labor and employment attorney for Fisher Phillips. Thank you so much for being here. As this is all happening, and it almost seems out of control at this point, that we have icon after icon, business leader after business leader falling. This must send shockwaves through the workplace. How do they deal with this?
It's interesting. This is way beyond anything we've seen before. I think people are questioning whether or not the policies and trainings and other things that employers have put in place are working. I think that you see women using voices that maybe they didn't use before. Being more willing to talk about things that they don't find acceptable in terms of workplace conduct. I think you find a different political climate than we've seen in the past, and I think employers are now cracking down, maybe where they might have excused behavior for whatever reason from someone who was in a particularly important position or someone they viewed as key to their organization. They won't excuse that behavior anymore.
But the question is the pendulum swinging quickly the other way? Because it seems like people are coming forward with allegations and accusations, and many times it's not corroborated, and then many times, at least from as far as we know, there's not evidence. It's he said, she said, and yet the accuser is being believed.
You highlight a really good point. We don't know. You know, we only see what we see on the media, like when you and I are having a conversation, what you read in the paper. We don't actually know what the investigation reveals or what the facts really are.
Or if there was an investigation.
Or if there was an investigation, although it would be very foolish for an employer to take action without any investigation. Part of a defense in an harassment case is that you've conducted a reasonable investigation, and that would be part of...
Stay on that point for 1 second.
Sure.
So it's safe for us to believe in that litany that Ellen just gave us a second ago, that each one of those were investigated by the workplace before they took action.
if they're my client, there would have been an investigation before they took action.
So there's more to it probably than we're reading.
I would think so. For a long time, there was the second guessing of the complainant. The person who brought the case forward or the complaint forward, there was, well, you know, what did you do to make the person think they could do that? Did this really happen? Has this happened to anybody else? Some questioning of the complainant is certainly reasonable in the context of an investigation. But there was almost this dismissiveness, I think, historically of women who brought complaints forward. And when you reference the pendulum swinging, now we're seeing, okay, we believe the women. Now the onus is on the person who's accused to show that they didn't engage in the conduct. That's more of a societal shift. That's not a legal shift.
Right, it can't be a legal shift, right? It's unconstitutional, and yet it's okay in the workplace?
Well, we have to, it's funny that a lot of people think, oh, well, that's not what the law says. Well, if you think about this, employers kind of put in their policies and procedures are in part to protect legal obligations, but in part to create a safe work environment, right? It doesn't really make sense if their policies and procedures align only with the law, because then you'd have to wait until somebody violated, for example, Title VII or the New Jersey law against discrimination before you could take action against them. That's not what we want. If somebody's behaving inappropriately or not in conformance with what we think is appropriate workplace conduct, we want to be able to say to them, hey, you're violating our policies. We expect you to adhere to more professional conduct in the workplace, even if that conduct that they were engaging in doesn't actually violate the law.
How much of this is driven by fear of litigation?
I think for some employers it is. There are certainly legal requirements that employers have policies and procedures and conduct investigations. But if you want a productive, happy workforce, you have to do this. I mean, if you think about it, if you have people in your workforce who feel that they're being discriminated against, feel that they're being harassed, feel that they're not taken seriously, they may not have a voice or may not have felt they had a voice in the past, but other people see that. And that will create morale problems, will decrease productivity. You might see a decrease in attendance. But we also now have social media. So you're going to hear about it on Glassdoor, on Twitter, on Facebook. So it matters.
Some of these cases we hear about, some of these cases we don't hear about it because the company takes care of it and they have a non-disclosure agreement signed, which in some of these cases are being thrown out the window. People are coming forward even though there's a non-disclosure agreement. Now there's a push in New Jersey and in some other states, including Pennsylvania, to get rid of non-disclosure agreements. Good thing, bad thing?
I actually don't think it's a great idea, and here's why. So if you're a plaintiff, right, let's say that maybe part of the allegations in the case are that you were actually fired for some type of conduct that you were involved with, and your contention is, well, I was fired because I was harassed. Well, you may not want that other piece of information to come out either, so you might want confidentiality. An employer might want to settle a case that they think has no merit because it's cheaper. If they can settle a case for $20,000 that they would have to spend $250,000 to try, they might say, well, from a business standpoint, this makes more sense. But we don't want that plaintiff's lawyer to be able to advertise, hey, call me and I'll get you $20,000 without having to do anything.
And that takes away that reason. So you wouldn't even have these agreements, or you'd have fewer of them if there's not a non-disclosure, because part of the bargaining is you don't talk about it and we'll give you a payoff. And so that would just go away. So it would force more people to go through the court system, the civil system.
It could. And by the way, you don't have to agree to a confidentiality provision. You know, if you bring a lawsuit and you want to settle, you might say, I'll settle, but not with confidentiality. It's not a requirement. It's part of the deal.
You're an attorney. Would you do that if you were representing a company?
Representing an employer? I might. It might depend on the circumstance. And certainly at some point, depending on when a case settles, certain things are already out there. For example, if a lawsuit has already been brought, you've already been through discovery. I've had cases settle in the middle of trial. All of that stuff is a matter of public record. The transcripts, the complaints, the documents that were submitted. So what's confidential might be in that case really just the terms of the settlement.
Well, it seems like in New Jersey this bill has bipartisan support, and I would imagine the governor is going to sign it. So this sounds like at this point it's going to go through. Do you think there's going to be lobbying against it?
You know, if I say this somewhat tongue-in-cheek, in New Jersey, I could see it going through. I could see something passing in California as well. I've represented clients all over the country, and I will say the two coasts tend to be the most employee-friendly.
Wow, we're now thrown in a pool with California?
Yeah, you're kind of like a step step-sibling to California in employment cases.
Thank you so much for coming in.
Thank you.
Lori Armstrong Halber, who is the labor and employment attorney for Fisher Phillips. When we come back, we'll continue talking about sexual harassment.